All right, everybody, if we could just collect ourselves, we're going to get started here in a second. Hope you're enjoying the delicious non-pizza lunch as promised. Let's see here. So welcome to our first speaker event of the spring semester, our fifth overall this year for the Federalist Society. For those of you who don't know me, I'm Richard Benson, the president of the Federalist Society here for Maurer School of Law this school year. And if I had to describe the Federalist Society, we're a group of people that likes to have interesting discussion about difficult events, especially emphasizing viewpoints that are not readily apparent in the law school. So we're happy that you're here to join us today for a very poignant topic. Our next event, by the way, is this upcoming Monday, where Professor Robin Fretwell Wilson will come to debate Richard Sutton on the merits of Indiana's proposed LGBT protections, and we'll have Moe's for that lunch. That's Monday at noon here in the Moot Court Room. For today's event, I would first like to acknowledge today's co-sponsor, the Black Law Students Association, who helped much of the logistics as well as providing the beverages. And it is a really, honestly, rare event, nationally speaking, to see FedSoc and BALSA co-sponsoring an event together. So I'm happy that we are able to get that done. So let's thank BALSA for their help today. So today we have a topic for everyone that has risen to prominence due to protests related to the Black Lives Matter movement and the deaths of Eric Garner, Michael Brown, Trayvon Martin, and by the media seen by people in their youth like John Oliver's very popular show in our generation. And disparate impacts in policing and sentencing are at the forefront of many minds today, especially those who are in the law school community. So today we've assembled a panel of 3 experts for you, and we hope to be done by a little bit after 1 o'clock and have question time until about 1:15. If you need to leave for class or work or anything else, feel free to do so quietly. And if you happen to be a practicing attorney desiring CLE credit, we have a sign-in form pending commission approval, so you can go ahead and do that. That's in the back there by the left door. I think we're going to be passing an email list as well during the event, so we can stay in contact about our future events. So let's see. Without further ado, let me go into the panel. We're going to have our main speaker for about 20 to 25 minutes, and then the professors from IU for about 15 minutes each, then move on to time for questions. Let's see here. Let's get my papers ready. So I'll go in reverse speaking order. Last we'll have Ryan Scott speak. He's a beloved criminal law professor here at Maurer and knows everything there is to know about sentencing. He received his BA from Macalester College in '98, JD from Minnesota Law in 2005, clerked on the 10th Circuit Court of Appeals, and then did a few years with Elmania and Myers in Washington before joining our faculty in 2009. Let's please welcome Professor Ryan Scott. And our second speaker today will be Assistant Professor of Criminal Justice, Akwasi Owusu-Bempah. Did I get that right? Good. Who received his PhD from the University of Toronto. He researches and is an expert in the intersection of race and the criminal justice system and is always loved by audiences on this topic. Please welcome today Professor Owusu-Bempah. And now for our first speaker today, who just dug out of the East Coast blizzard and made his way. So we're very thankful that he was able to arrive, and I'm sure he appreciates ground that doesn't have that much snow on it. So Paul Larkin is the Heritage Foundation in Washington, D.C. senior expert in criminal law. He focuses his research and advocacy on stopping the abuse of criminal law process, mostly on the federal level, often with a focus of over-criminalization and the intersection of regulation and criminalization. He received his Juris Doctor from Stanford Law in 1980 and has a master's in public policy from George Washington University from 2010. He has argued 27 cases before the Supreme Court. For comparison's sake, Ted Cruz brags about 9. So maybe Larkin should be in Iowa right now. Mr. Larkin's resume includes the Department of Justice, clerking for impressive judges, including Robert Bork, and was involved in the criminal law reforms in the 90s under Senator Orrin Hatch. We try to bring you experts in the field here at FedSoc who can add to our education here at Maurer, and Paul Larkin is absolutely no exception. So without further ado, please welcome our first speaker on making criminal justice work for all Americans, Mr. Paul Larkin.
Let me say thank you very much to the Black Law Students Organization and to the Federalist Society for inviting me to come and sponsoring this event. I have to say, it is funny. When I first agreed to do this, I thought I was going to have far more difficulty getting into Indiana than getting out of Washington, D.C. But I'm very fortunate that everything worked out well, because I've been looking forward to coming ever since I was first given the opportunity. Let me say I'm going to talk about the intersection of three contentious issues in policy in criminal justice today. Criminal justice policy generally, drug policy, and racial policy are three very contentious issues in American society. They intersect in at least two areas that we see and hear about often. One is what are called Terry stops, which I'll explain in a minute. Those are just brief stops that individuals oftentimes undergo if the police have reasonable suspicion to believe they're engaged in a crime. And then it comes up in sentencing, particularly sentencing for crack cocaine offenses. The reason is the sentence for crack cocaine is far more serious than it is for powdered cocaine. At one time, it was essentially a 100-to-1 ratio. Now it's down to an 18-to-1 ratio, but only on a going-forward basis. The result is it has created a tremendous disparity in the black versus white population for drug offenses, particularly crack offenses, in the federal prisons. State laws that have similar laws will have the same problem. So it's the intersection of those three types of issues that I want to talk about. And I guess the point I want to make at bottom is that it is critical in understanding the Terry stop and sentencing issues to realize that how you look at them depends tremendously, if not critically, on the perspective you take in how to analyze them. Now let me start with Terry stops. For those of you who haven't taken criminal procedure or don't have prior experience in law enforcement, sometimes in law school, some of the people who attend and then come to events like this have been police officers and so know what Terry stops are like from actually having done them. A Terry stop is a brief detention of an individual for the purpose of questioning. It can't be done on random. It can only be done if the officer has reasonable suspicion that a crime has been committed. Now, reasonable suspicion is a term that doesn't invite any particular type of numerical likelihood that someone is involved in a crime. What happened in Terry was a person was casing a jewelry store. It was the sort of classic behavior. Somebody was walking back in front of the jewelry store trying to obscure the fact that he was trying to sneak and see what was going on, see how many people were inside and the like. And a local police officer thought, in fact, that was what was happening. And he stopped him, questioned him, and at one point reached into his coat pocket and found a pistol. He was then arrested for possession of the pistol, and the case developed on the ground that the stop and the search was unlawful. The Supreme Court wound up upholding both. The stop has to be justified on the basis of reasonable suspicion. The search has to be justified on the basis of a reasonable belief that someone is armed and dangerous. And the evidence for each one may overlap with the other, but they have to be independently justified. The mere fact that you can stop someone based on reasonable belief that the person's involved in a crime doesn't mean you have reasonable belief that that person's armed. I mean, for example, if someone just gets off a plane and you have reasonable suspicion that person may be carrying narcotics, if the person has just gotten off an airline in the United States, the person would have gone through an area and therefore been checked, so you wouldn't have reasonable belief that person has been armed. So you have situations that can arise where you could have the one and not the other, and you have to look at the two issues separately. I mean, when I was a federal agent, I was at a gun range one time, and I had a friend who was there as well who was a former D.C. police officer. And someone came in, because it was a gun store attached to the gun range, and this person gave every evidence that he was casing the place for a robbery. He was the sort of person who wanted to know where all the cameras were, but wanted to make sure that they didn't get a good picture of them. He wanted to see everything in the gun area, but didn't want to look at anything in particular. And while it wasn't a blistering summer day, it was hot, and he was wearing a long coat. And those of you who've seen Beverly Hills Cop 1 know that that can give rise to a question as to why someone is overdressed when it's 90-plus degrees. So you have to look at all the facts of individual cases to justify both of those types of events. The problem is, in a great many neighborhoods, particularly in a great many neighborhoods that are predominantly African American, there have been a large number of stops. And it has given rise to complaints that the police are engaged in racial behavior. That is, they're racially minded, or they're even, in fact, bigoted. They're either relying too much on the race of the suspect, or they're drawing the impermissible inference that because a person is black, a person has committed a crime, and therefore the person has a firearm, and I can stop the person for questioning and conduct a pat-down to see if the person, in fact, is armed. This came up in a famous case decided a few years ago in New York City called Floyd. The judge there had a major class action involving about 19,000 people. And the question was, were these stops justified? The plaintiffs argued that this was evidence of impermissible stops in all these sorts of cases. And the judge found that the stops occurred in violation of the Fourth Amendment and occurred in violation of the Equal Protection Clause. Now, the judge was clearly wrong, I think, on the Fourth Amendment, but may have been right on the Equal Protection Clause. Part of the reason she was wrong on the Fourth Amendment is you can't establish in one case what happened in 19,000 stops. I mean, the Supreme Court's substantive law says you have to look at the facts of each case. So you can't take 19,000 cases and do a statistical analysis to see what the percentage is of correct versus incorrect stops. That is not the way you can look at it. Plus, in addition, the judge was troubled by the fact that only 95% of the stops were found to be justified, which means 5% were not. If you look, however, at the levels of justification necessary to do this, a 95% success rate is extraordinarily good. Reasonable suspicion, we know, is less than probable cause. Probable cause justifies an arrest. Reasonable suspicion justifies a brief detention for questioning. Probable cause doesn't even require that it be more likely than not the case that a person has committed a crime. It's less than 50%. The Supreme Court so held in Illinois versus Gates. The Supreme Court held in United States versus Socolow that reasonable suspicion is less than that. And both of them are less than the beyond a reasonable doubt standard necessary at the guilt stage, which you could say approaches 99%. So a 95% success rate, if you're allowed to look at macro numbers, is in fact extraordinarily good, because what it means is you have such a large number of permissible stops that it almost reaches the level at which you could justify proof beyond a reasonable doubt if you're allowed to look at statistical evidence. Now, the judge, as I say, made a mistake in that regard, but she may have been right on the equal protection component, which looks at it separately. That doesn't look at simply whether you have individual stops justified on the basis of evidence of a crime rather than race. It also takes into account the directions that people get from superiors. And in this case, she found that some of the evidence supported the inference that the superiors in the NYPD had directed the attention of street officers to focus far too heavily simply on the race of people rather than on the evidence and circumstances. Part of the evidence she found for that was there was never any punishment handed out when someone got stops wrong, regardless of the number of stops that were mistaken. And you would expect that if the supervisors were concerned about this, they would at least have ordered retraining, that is, legal training, for some of the officers, and they hadn't. They also didn't affect their promotions or other status in the department. Plus, she relied on a particular statement by the then police commissioner Ray Kelly, where he said he was encouraging the officers in order to engage in aggressive patrol in predominantly black areas to scare the people out on the street. She construed that as meaning they were being directed to rely too heavily on race. And so she found that the policies from above were tainted, and therefore the plaintiff should win. Now, that's a very different inquiry than the one whether you violated the Fourth Amendment, because you can look at general level issues to decide whether supervisors have directed people to engage in an unlawful policy. And that is the way you can look at this under the Equal Protection Clause. You still have to establish an intent to discriminate, but you're allowed to reify the issue to the supervisor level to see if, in fact, what's happening is directions being given that are impermissible rather than the actions taken by the officers are impermissible. Keep in mind, however, I said the perspective counts, and I will get to that in a minute because the perspective also comes up in connection with sentencing for crack cocaine. The crack cocaine laws were adopted in 1986, that is, the ones that are really most problematic. In 1986, because of the sudden emergence of crack cocaine into one of the drugs that can be sold in the United States, two professional athletes, Johnny Rogers, a fellow for the Cleveland Browns who played in their secondary, and I think it's Ken Bias, although I think I've gotten his first name wrong, who had just been a player for Maryland, who had just been drafted first by the Boston Celtics. Both died from the use of cocaine. Now, the irony to this is, in each case, the cocaine they used was powdered, not crack. But nonetheless, the deaths gave rise to this fear that crack cocaine was going to take over. It was going to democratize the use of cocaine because it could be purchased very cheaply in smaller amounts. Powdered cocaine was far more expensive. And so this was going to increase the number of people who were going to use it. And there was a tremendous fear expressed by the Congressional Black Caucus that it was going to decimate black communities. So what happened was Congress passed a law in 1986 imposing a mandatory minimum sentence. Now, the original minimum sentence was supposed to be on a ratio of 20-1. But then, as things often happen in Congress, there was a bidding war so that each side could show how tough they were on drugs. And it wound up getting bid up to 100. And that's where it was until 2010, when President Obama signed an act that reduced the ratio from 100-1 to 18-1. But the way to look at this problem, I think, as the one that ties in with the problem of Terry stops, is that of the perspective. The problem in each case is that probably only 1% of the people in largely African American communities are engaged in drug trafficking. You have a very small number of people who are likely to be the offenders at which these sorts of drug laws or drug practices are being addressed. The problem of focusing simply on the race of the defendant rather than the race of the community is that you forget the victims of the crimes that are being committed, not simply the crime of actually possessing and using the drug in violation of that federal law, but all the allied, associated, ancillary crimes that come up, as well as the violence involved. I mean, people who traffic in drugs don't have the ability to go to the police and ask for help if someone refuses to pay or if someone tries to steal their supply. They can rely only on self-help. And you don't have to be Glenn Fry to know that if you carry a lot of cash, you're going to have people that are armed. That just is a natural combination that you've seen not simply in predominantly black communities, but everywhere in the United States. Drug trafficking produces enormous amounts of money, and people are armed to make sure they get to keep it. So if you focus just on the race of the suspect or the race of the defendant, you're missing the fact that you have a far, far greater number of people in the community that in fact are the same race. Housing patterns being what they are in the United States, and drug distribution practices being what they are in the United States. Historically, crack cocaine has been sold in predominantly black neighborhoods, oftentimes in what were called open-air markets. Now, they've sometimes been driven indoors more recently because of places like New York City where they've aggressively tried to stop this. But for a very long time, that was the practice. So what you have is a practice that, while on its face it looks to be racially discriminatory, if you drill down a little, you wind up seeing that the primary beneficiaries of the practice are the same race as the people who are being arrested and charged and convicted. The interesting question arises is, what do you do if, in fact, the people in those neighborhoods are now of a mind that they too oppose the laws as they are being written and as they are being applied? What do you do if the people in those neighborhoods come to believe that even though they hate the sin of drug trafficking, they still love the sinner of the people in their neighborhoods? They still love the people who are their fathers and brothers and sisters, cousins, etc. And they still want them to at least have some opportunity other than just spending the rest of their life in prison, because some of these sentences are actually quite long. That is a serious problem, and that is one that I think unfortunately hasn't gotten a lot of the debate. Most of the debate, I think, is focused simply on the threshold question of whether the laws have a racially disparate impact, and because they do, the argument has been made that we should change them and get rid of them. They haven't also included the question of whether the primary beneficiaries are the same race as the defendants, and they also haven't included the further question of whether the people in those communities who are the beneficiaries themselves have a different view in this regard. So the level of debate, I think, unfortunately, has gone on too much at that first level, which is only the superficial level. It has to be brought down and drilled down to the other two in order to know the answers to these problems. So the final thing I want to say is that sort of debate has been going on, and there are bills pending before Congress that will deal with some of these problems. The bills pending before Congress focus on sentencing, not police practices. Most of the problems with stop and frisk are problems that occur in police departments and sheriff's departments, not federal law enforcement agencies. Most federal law enforcement agencies have narrowly targeted responsibilities. It doesn't mean they won't be involved in street crimes in some places. For example, the FBI, located in Washington, D.C., will be working with the D.C. police on handling street crimes. So you will have FBI agents involved in this. You will have perhaps some DEA agents involved too. But even in the case of the DEA, their focus is on very large-scale trafficking. They're dealing with trying to disrupt the flow of drugs across the border from cartels in Mexico and the like. They're not going to be focused on the street sales. They don't have enough agents to do that, and they have state and local people to do that, so they allocate their responsibilities differently. But in the case of the sentencing laws that Congress passed in 1986 are federal laws, and they are being re-examined. And there are different approaches to it. One approach is simply to get rid of all the mandatory minimums and return discretion to the district courts under the sentencing guidelines. There are people who have supported that. Rand Paul is one, and the minority chief of the Senate Judiciary Committee, whose name I apologize, I can't remember, he's a senator from Vermont, Pat Leahy also has joined in that, so the two of them support that. That hasn't gotten a lot of support. But what has gotten a lot of support are different laws that will increase the sentencing discretion that judges have so that they can impose non-mandatory sentences depending on the circumstances in each case. The Senate Judiciary Committee has passed such a bill out of committee. The House is considering a similar bill. But here's the irony, and here's why I say you have to look at this oftentimes from perspective. What may threaten the passage of these laws is not a dispute between blacks and whites, Republicans and Democrats. The House also wants to include some reforms dealing with the mental elements in a variety of different federal crimes. There are a whole passel of federal offenses that operate on a strict liability basis, and Congress would like to modify that. The Senate so far has been shown to be unwilling to do that, and the House is demanding that it be done in order for the House to pass the same type of reforms that the Senate has. So what you have, ironically, is now a disagreement between two different public interest groups that are not defined necessarily by race. You have people that want to reduce the sentences in this area, which are both black and white, various organizations such as the ACLU and the like, who are not primarily focused on racial issues, support that. And the groups that are opposing the reforms on mens rea are primarily environmental groups. So what you have is two different interest groups opposing each other and opposing these sorts of reforms, neither of which are broken down by race, which is why, as I said at the outset, the important thing in this sort of debate is to focus on the perspective sometimes of the offender, the perspective sometimes of the people in the community, and the perspectives of the different interest groups that support and oppose the different reforms. With that, let me thank you very much and hand it over to my colleagues on the panel.
All right, thank you, Mr. Larkin, for those remarks. I'm going to have to remember to work in Beverly Hills Cop references to my future talks, although I'm not sure everyone in the room here would get the references. Thank you for the organizers for inviting me to speak today. Of course, making criminal justice work. Criminal justice is increasingly timely and topical. Issues related to drug prohibition, juvenile justice, mass incarceration, the death penalty, gun control, immigration, terrorism, and of course many aspects of policing are on the minds of policymakers, academics, and members of the public. Just to give you a bit of an example here, I'm going to focus mainly on policing. As noted in the introduction, I'm a criminal justice professor here at IU, and most of my research does focus in the area of policing. And when I was just opening up my criminal justice class to students this term, I read them a couple of quotes that I'm going to read to you. And this is first a piece from a somewhat conservative piece, and then from a more liberal outlet. And this is a quote on something that Ta-Nehisi Coates has said around policing. So in the Atlantic, Ta-Nehisi Coates argues that part of the reason that police officers are coming under so much scrutiny at the moment is because they're expected to do too much. At some point, Americans decided that the best answer to every social ill lay in the power of the criminal justice system. He writes, vexing social problems such as homelessness, drug use, and mental illness are now handled by armed men and women who are trained to enforce compliance and not offer therapy. He goes on to say, peel back the layers of most of the recent police shootings that have captured public attention, and you'll find that a broad societal problem underpins them. Again, society has thrown up her hands and said to the criminal justice system, look, you deal with this. Now, in a much more liberal outlet, Professor Alex Vitale of Brooklyn College, writes, we have to take steps back to dial down our reliance on the police as a primary tool of resolving neighborhood crime and disorder problems. For instance, we've overwhelming evidence that the policing of drugs is coercive and a counterproductive strategy that's done nothing to reduce the negative impact of drugs on communities. Drugs are a public health problem, not a policing problem, and the same approach should be taken for sex work. And this kind of forms the basis. Main point that I want to make in this talk today is that we really need to rethink what it is that the police do in our society if we're going to make policing and criminal justice work for us as Americans. And so many of us call on the police in times of need, of course, and we expect them to provide mundane functions like directing traffic. Now, the police, of course, provide an essential 24/7, 365 service that most of us would agree is probably essential. Nonetheless, citizen levels of trust and confidence in the police are at all-time lows. It's not unreasonable, I would say right now, to suggest that there is what we'd call a confidence in crisis with regards to policing. And much of this has been sparked by instances of excessive force or police shootings of often unarmed racialized suspects or people suffering from mental illness. Now, in order to improve the delivery of policing in the United States, the Department of Justice has committed to working in 3 specific areas, specifically coming out of the fallout from Ferguson. And these specific areas relate to procedural justice, to reducing implicit bias, and then to dealing with what's called racial reconciliation. And I'll go through these just very briefly. So on procedural justice theory emerges largely from the work of Tom Tyler. He's a social psychologist at Yale. And the basic premise of his argument is that the outcome of a specific encounter with a member of the public from a police officer is less important than how an individual is treated during that encounter. That is that that citizens are more likely to view the police, and as a result the state, as legitimate if they're treated in a fair and procedurally just manner by that officer. Meaning that when a police officer stops an individual and asks them rudely for their identification or is demanding in a way that they not necessarily need be, that citizen's going to leave with a kind of tainted view of policing. And importantly, negative views of the police, perceptions of illegitimacy, have been shown to increase the likelihood that people will break the law and that they'll be less likely to comply with officers' directives. The second component relates to implicit bias. And so our brains do some kind of fascinating things, and we don't necessarily take in, or we don't have to process all of the information that we see. Our brain does a large part of that for us. It does so in relation to race, and based on stereotypes that are prevalent in our society, our brain creates a number of mental shortcuts that prompt us to act in certain ways. And there have been a number of studies in policing specifically showing that when officers are prompted with a black face versus a white face, that they're more likely to shoot first. Emerging research showing that black suspects are dehumanized, that black youth specifically are dehumanized, and that that dehumanization increases the likelihood of force as well. And so the police are taking steps, the Department of Justice is taking steps to increase implicit bias training within policing. And finally, there's this idea of reconciliation. And this idea of reconciliation is based on the premise that we can't hold the police accountable for all of the ills in police-community relations, nor can we hold communities accountable. Historically, the police have been used as a tool of racial oppression in this country, and I think the FBI Director James Comey's comments to that effect earlier in the year hold a lot of weight. But also, we need to understand that communities that are reluctant to cooperate with police, the stop snitching culture, does very little to promote public safety. And in order to increase or to improve police-community relations, both sides need to take some kind of responsibility for their role in producing the status quo. Now, while these efforts are largely commendable, they leave the broader policing framework relatively untouched. That is, the proposed initiatives make little attempt to fix our current system without questioning the underarching principles or overarching model of policing itself. So we don't ask the question, what function do we want the police to perform in the 21st century? And indeed, as a policing scholar, I know that our current model of policing is almost 200 years old. And of course, policing has attempted to keep pace with the immense change that our society's experienced, things like increased urbanization, the emergence of new technologies, and the likes. Now, however, some of these emergent technologies have actually served to sour relations between communities and the police. The car, the telephone, the radio, for example, all served to sever the police from the communities that they served. And this gulf, in part, has led to a lack of communication between the police and the public, and has led the police to lose touch with the community and the community's needs and concerns. So again, I think it's time as not only Americans, I'm here by way of Canada and the UK, as Westerners to rethink what it is that we want the police to do. Across jurisdictions, we're seeing citizens and policymakers express concern about the costs of policing, about how police treat different population groups, again, especially in relation to race, concern about police use of force, really testing the limits of what society views as acceptable use of force by an agent of the state, and relatedly concern about how the police treat the mentally ill. And oftentimes, use of force cases do involve mentally ill or distressed people. Take, for example, the common quote or finding that the Cook County Jail in Chicago is the largest mental health provider in the United States. Well, I'm pretty sure most of those people didn't walk up to the front door and just ask to be admitted, right? They would have been in police custody first. And so it is really the police in America who are our frontline mental health providers. And so this is the case also in many other Western nations. So again, just to reiterate, to get back to the main point, how do we get policing, how do we get criminal justice to function effectively for all Americans? I think in order to answer that question, we need to rethink what it is we want the police to do. Do we want the police to be directing traffic? Do we want the police to be in schools, which we know leads to net widening? Do we want someone armed with a badge and a gun to be dealing with some of our most distressed subpopulations? Many of these things could be done with people who are likely to use much less force and who probably cost a little bit less money. So if we want to make policing work for all Americans, again, we need to determine what we want the police to do, and then we can go about determining how we want them to do it. Thank you.
Purple? Thanks again for the invitation. It is terrific to see FedSoc and BALSA teaming up to have an event. It is an unusual collaboration, but this is an area of unusual collaborations right now. Criminal justice is an area where strange political bedfellows are active and engaged both at the federal and state level in serious reforms. And that's been an encouraging sign. It's been an area where it's been tough to break political log jams in the past, and it's been pleasant to see both bipartisan efforts at the federal level and coalitions at the state level, including here in Indiana, aimed at various kinds of criminal justice reform. I'm going to talk about two big issues in sentencing policy that are at the heart of debates about the criminal justice system as a whole. The first is mass incarceration, and the second is race disparity, especially race disparity in the prison population, in mass incarceration. And the theme of my remarks is going to be thoroughly depressing, because I'm going to talk about big challenges, deep and profound challenges in these areas that makes it tough for reformers, even well-intentioned, cooperating across the aisle kinds of reformers, to address these momentous challenges in the United States. So let's start with mass incarceration, and I wanted to show some PowerPoint slides just to give you a sense of the scale of the problem. Here's the U.S. prison population in the state and federal level from 1925 to 2013. You can see it has ballooned, particularly in the 1980s and the 1990s. It has continued to increase in the 2000s, only reaching a plateau of sorts, approaching 1.6 million people in prison in the United States. That's an extraordinary ramp up, and it's one that has not tracked crime rates especially well. That is to say, the prison population has continued to increase even though crime rates have declined since the 1990s. Here's a closer breakdown of what the federal and state prison populations look like. Note that state prisons account for more than 90% of people who are serving more than a year in prison. We could actually add some more. There are people serving who are in local jails for a short period of time. They might be awaiting trial. They might be just arrested overnight. There's some amount of people who are also in custody at the state jail level. This is just looking at people sentenced to state or federal prison for a year or more, and the numbers are eye-popping. It's over 1.5 million people. It has declined a little bit in the last few years. From its peak in 2009, we've seen a slight decrease, although that's only at the state level. The federal prison population has continued to increase. There are profound costs to this level of imprisonment, which is really unique compared to the rest of the world. Ours is by far the largest prison population on the planet. It's way out of step with other Western democracies on a per population basis. And as a consequence, there are both enormous human costs for the prisoners who spend their lives in detention. There are enormous financial costs as well, and that's one of the reasons I think that there's been so much bipartisan activity in Indiana and in a lot of other states. The cost of incarceration has become unacceptable, that we have to do something to reduce the number of people in our prisons. To give you a sense of what that trajectory has looked like, here in billions of dollars is how much states are spending on incarceration. This is corrections budgets generally, and you can see it's gone from $15 billion in the early 1980s to well over $50 billion, and this is adjusted for inflation. Note as well that 3/4 of that expenditure, it comes from prisons. This is by far the biggest line item in correction spending. So this is not an increase in probation and supervision costs. It's driven by prison expenditures. That kind of spending is, in a time of tight budgets at the state level, is difficult to sustain. Okay, so enormous human costs and financial costs to mass incarceration. In addition, there is a stark race disparity in the rates of imprisonment. So here, per 100,000 people are rates of imprisonment. The United States at 471, that's an eye-popping number compared to the rest of the world. But look at the differences among races. It's much higher for men than women. That's true everywhere. But white men have a per 100,000 rate of 465. For black men, the rate is almost 6 times as high, over 2,000 per 100,000 individuals. For Hispanic men, also a staggering multiple compared to white men. The numbers for women across the board are much lower, but again, more pronounced among black and Hispanic women. That kind of stark disparity is troubling for all sorts of reasons. Let's start by acknowledging that there are differences among racial groups in rates of crime. When we look at victimization surveys, it's true that violent crime, the reported rates of violent crime among black men, for example, are higher than the population would otherwise suggest. But it doesn't come anywhere near explaining this level of disparity. It just is not the case that white people commit 6 times fewer offenses than black people. No crime victimization survey suggests anywhere close to that. The difference, as social scientists tend to put it, involves some sort of unexplained racial disparity, which is to say, not explained in terms of the nature of the crime, the circumstances surrounding the offense, other characteristics. There's got to be some explanation for this level of disparity. And it's troubling, again, for all sorts of reasons. Not only does this mean that the burden of mass incarceration disproportionately falls on black people, it affects the families of victims, of the families of people who are incarcerated, it affects communities where they come from. It also fuels the kind of distrust that contributes to difficulties in policing and calls into question the legitimacy of the criminal justice system. Race disparity of this level, problematic for all sorts of reasons. And yet, there are profound difficulties that reformers will encounter when trying to counteract mass incarceration and this level of race disparity. And I'll summarize them briefly now. Let me start by talking about volume. The increase in the prison population in the United States is due almost entirely to volume as opposed to increases in sentencing. That is to say, we are convicting more people for more crimes today than we were in the 1980s. Bill Stuntz, the late Bill Stuntz, did a great analysis of trends in police in the prison population since the 1980s and calculates that if we held sentences absolutely steady from the early 1980s, if we had no mandatory minimums, no three strikes laws, no increases in the sentence imposed per crime, that would blunt the increase in the prison population by only about 20%. About 80% of the increase in the prison population is due to volume. We're able to, and we are, prosecuting and convicting more people than ever before. That's partly because plea bargaining has made it possible. Trials have essentially evaporated in state and federal criminal proceedings. It means that we're just, the crime rate has declined, but we're still imprisoning more people for crime. So volume is a big problem. And so unless we're ready to back off on the number of people who are guilty of crimes, who we convict of those crimes, the prison population is likely to increase or at least remain at its current extremely high levels. A second major problem, this is a political as well as practical problem, is that violent crime is the driver of the imprisonment rate. The discussion in this area is often about drug crime, and drug crimes are frequently overpunished. That's especially true in some areas. The crack-powder ratio is a very good example. But if you look at the prison population as a whole, violent crimes, this is state prisons, violent crimes represent more than half of state prisoners. Drug crimes, a comparatively small amount, about 15.5%. When California was under a court order to reduce its prison size to deal with prison conditions so atrocious that they violated the Eighth Amendment, the governor announced a few guiding principles, and one of the guiding principles for who we're going to remove from the prison population. Well, we have to start. Absolutely no one who's committed a violent crime can be released. And there are a number of other criteria that the governor put in place. Well, good grief. By the time you were done ticking through all the unacceptable people who could never be let out of prison, there was almost no one left. In other words, if we're serious about mass incarceration, violent crime is what's driving the prison population. Unless and until we're prepared to confront the fact that, in violent crime, this is roughly 4 different groups form the violent crime population. It's homicide, murder and manslaughter, rape and sexual assault, assault and other kinds of direct physical injuries, and robbery. Those are the 4, and they're roughly equal in terms of the state prison population. So unless we're prepared to reduce sentences or stop imprisoning people for those kinds of offenses, the prison population is going to remain at its very high levels. And so it's politically challenging. Actually, sentencing reform at the federal level right now is imperiled in part because there are a number of senators who are very concerned about releasing or reducing the sentences of people who've been convicted of violent crimes. It's the population that is least politically sympathetic, and as a consequence, it stands as a real obstacle to reducing the prison population. A third challenge, you can't see the bottom of the slide, is that incarceration has at least some relationship to crime rates, and there's a risk that reducing the prison population will result in an increase in crime. This is a heavily contested area among criminologists, and I won't get into the details here, but no serious social scientist doubts that there is at least some reduction in crime that has occurred by putting 2 million people in prison. As a consequence, reducing the prison population will have some criminogenic effect, it will allow some people who are presently incapacitated incapacitated to commit crimes. And so that's another political drawback. Reducing the prison population will likely have some kind of effect on crime rates. I'll also note that the crime rates have been declining since the 1990s, and yet the prison population has continued to increase, and the volume of prosecutions has continued to increase. Those are that dysfunction, that mismatch between crime rates and the volume of prosecution is at the heart of this issue, and yet it's very hard to get your hands around, and it's hard to explain why prosecutors, one argument would be, ought to be convicting fewer people, ought to be declining to prosecute, even in the face of strong evidence of guilt. That's what it would take to reduce the prison rate for reformers. Okay, finally, some deep problems, difficulties confronting race disparity. To begin with, sentencing law as a tool for addressing mass incarceration and the race disparity is especially difficult because the sources of disparity, of race disparity at sentencing, can come from a number of different sources. It might be the judges are either explicitly or implicitly biased, more likely to impose harsh sentences for black offenders. It might be that there are prosecutorial decisions that feed this effect. There's some pretty good research at the federal level that mandatory minimums are deployed by prosecutors in a racially disparate way that fuels those kinds of outcomes. But a major consequence, and based on the evidence at the state and federal level, the biggest source of disparity in sentencing comes not from the discretionary decisions of those actors, but from the substantive law of crime and punishment, which has racially disparate impacts. Crack powder is one example. Another very clear example at the state level is criminal history as a source of sentences. One of the classic reasons to impose a more serious sentence is the severity and length of an offender's prior criminal record. And that has a racially disparate effect because black offenders, on average, have longer rap sheets when they're convicted for whatever crime sent them to prison. At the state level in states like Minnesota, it accounts for about 40% of the disparity between judges comes not from discretionary decisions, but from just the criminal history score that black offenders compared to white offenders have under the state's sentencing guidelines. So that suggests that tackling race disparity through sentencing law would require rethinking race-neutral criteria that have a racially disparate effect. A second major challenge in this area is disentangling the effects at sentencing from earlier decisions, especially bias in policing. And really this opens up a much broader discussion of how race and crime interact. Other sources, criminogenic sources, include things like poverty, education, family structure. Because all of those fuel crime, all of those are difficult to separate out. Sentencing law is ill-equipped to address earlier stages in the process, the policing process, and all of those other sources. And it feels like a cop-out to say we can't really solve the prison disparity in prison populations until we first solve education and employment discrimination, family structure, etc. Yet all of those are problems that unquestionably fuel disparities at earlier stages and result in disparities at the final stage. And finally, I'm so glad Professor Larkin mentioned this. Race and victimization is a major part of this story and a major challenge when trying to address mass incarceration and race disparities in the prison population. It's the overwhelming majority of crime in the United States is intraracial. That is to say that white people are victimized overwhelmingly by white people in terms of violent and property crime. Black people overwhelmingly victimized by black people in terms of violent and property crime. That means if you believe that imprisonment has reduced levels of crime and thus that decarceration efforts would result in increases in crime, the communities most likely to suffer from that effort, the places most at risk, are communities of color, right? If we reduce that race disparity, it's victims of that same racial group who had the most to lose if we're wrong about if there are risks inherent in decarceration that's aimed at reducing race disparity. I hope these aren't insuperable problems, but I want to set the stage by just talking about the major political and practical obstacles to making meaningful change in this area. And efforts like the federal effort, which I fully support. I think it's a terrific bill, and I hope it passes. And efforts as like we've seen in Indiana, I fear that they are nibbling around the edges and that they won't be able to meaningfully address the big picture problems because of these much more structural issues with how criminal justice produces large levels of imprisonment and race disparity in the United States. Thanks.
All righty. This one on. There it is. There we go. All right, for those who are still hanging around, it is approaching 1 o'clock, but I wanted to get a couple chances for questions out here in the audience, and I'll just restate my juvenile justice question from earlier. So the President Obama just changed, I keep forgetting this, solitary confinement, and then the Supreme Court changed life sentences or made it retroactive. So I was curious if anyone on the panel wanted to see what would be the impact of those two major decisions of the last week.
For the people involved, it's a tremendous decision. But I think the number of people who will be affected by those two is going to be extraordinarily small. The federal government doesn't imprison very many juveniles. And so within the federal system, eliminating that is not going to release thousands of people into a general population. The number of people who were sentenced automatically to life imprisonment as juveniles, my guess is probably were relatively small as well, although I'm sure in that case they did mention the numbers. And for each of them, this is extraordinarily valuable. I think generally, though, the number of people is going to be far less than the other sorts of reforms my colleagues talked about. And let me just say, I agree with a lot of what everyone has said before me. I mean, for example, I think we do ask cops to do too much. That's absolutely right. Cops, the police, the criminal justice system has become the mental health system in the 21st century. There's no doubt about that. You can't get people to allocate money to the mental health system unless you tell them it's a mental health system that is an adjunct to the criminal justice system. The cops should dial back. Absolutely. We don't want to militarize police officers. There's a difference between armies and police officers. And having police officers show up in Humvees that still have the yellow paint on them from the desert gives the wrong impression. Not every local police department needs a SWAT team. They all want them because that's what all the big boys do. But not everybody needs it. And unfortunately, once you have one, that's all they want to do is train. And that means there are fewer people to do the general police work that's necessary. And, you know, if more police officers used 9 words when they finish a stop or something, if it turns out the person does need to be arrested, I was wrong, I am sorry for any inconvenience, that would probably help a lot of police community relations. And you don't see them do that. They don't want to do it because they think they have to be a lion rather than a lamb. But there are times being a lamb is going to be more effective in the long run. Okay? You need not only the police chief to go down and talk to people in the community, you need people on the street, the police officers, to do that. I mean, back in the 60s and 70s, they put police in cars. Why? Because they thought their whole role was to be a responder, and they could get to crimes faster in vehicles than walking the beat. Well, you lost the connection between individual police officers and their communities as a result of that. And that hurts. And as later, what happens with imprisonment is in the short run, yes, the more you imprison, there's going to be a decrease in crime. But there's a breaking point where further increases in imprisonment are going to increase crime. And one of the problems is that may be what's happening in black communities. You are losing fathers, okay? If you don't have them there, you don't have them as the restraint on adolescents. And that leads to an increase in crime because they don't have some of the natural restraints that have historically kept crime down, which is families, church, community, and the like. You get rid of males from a community because you're putting them away for crimes. You now have women and adolescents, and you don't have men to help in that regard. There are a lot of other things I could say because I agree with a lot of what my colleagues have said, but I don't want to eliminate any chance for questions.
All right. Any other questions at all? In the back.
How do you see for-profit prisons playing a role in mass incarceration?
It's actually a fairly small segment of the population. I was interested in that, looking at these BJS reports on the prison population. It's about 5% of the U.S. prison population is in private prisons. It's a slightly larger, actually, at the federal level than at the state level. So far, private prisons, for-profit prisons, are a relatively small part of the story. There are states where they play a quite prominent role. In the federal system, they play a quite prominent role. But most states don't use any private prisons, and the total population is still 95+% of the prison population is still in state-run prisons today. So I don't think it's been a major driver of the prison population. It does, private prisons, the concern being when you get a sort of vested economic interest in continued imprisonment, that means lobbying efforts and other forces that tend to counter reform efforts or decarceration efforts. But I do think so far it's been a relatively small part of the story, at least in terms of overall volume.
I think that you kind of touched upon, though, something that's often not considered, which is the lobbying efforts, right, and the increase in putativeness that comes from the private prison industry, even if those prisoners aren't going directly into private prison. Between the private prison lobby and the gun lobby, we got a lot of problematic lobbying.
Yeah, and it also shows another area where that shows up, where you're creating perhaps the wrong incentives, is in civil asset forfeiture. I mean, one of the things that's happened is over time we have shifted the way civil asset forfeiture works. Rather than the money going into the general treasury, it goes to the police department. So now you have police departments engaging in policing for profit. They're more likely to spend time on crimes that lead to something they can seize and fund their activities. And then that makes them an even more powerful voice in the legislature, because they can go to the legislature and say, well, you certainly don't want to increase taxes, so you can't take away our ability to engage in civil asset forfeiture. The creation of private prisons creates a new interest group now, the people in the community that have the private prison and the politicians who represent them, as well as the businesses. And so you're creating additional incentives and disincentives for the criminal justice system to deal with that are not necessarily positive.
Let me add one more on the subject of lobbying. Private prisons have a lobbying interest. Public prisons do as well, because their employees are often unionized, and particularly in California, the union of prison guards, people who work at prisons, is enormously powerful. So I could maybe add this to my slide of yet more deep problems, challenges confronting quite a few vested economic interests of one sort or another that oppose any effort that would result in less business for the prisons.
We were talking about the strange bedfellows on this issue, and I was wondering what is going on in the House right now. It sounds like the Koch brothers might be involved. They've surprised a few people being involved with criminal justice, and now it sounds like they want some environmental crimes watered down. I was wondering if you guys had any more information on that.
I think they have been involved in the process. I mean, the story in the media has been that they've been meeting with people in the White House and the White House staff who deal with criminal justice reform. I don't have any firsthand information on this. And I think in terms of the watering down of environmental crimes, it's a different type of problem. That's a problem that comes under the rubric of over-criminalization. The question is, have we made things into crimes that we should not have? Or, in the process of making them into crimes, have we exposed the people who are at issue to too great a risk of breaking the law when they engage in non-blameworthy conduct? I mean, the environmental area is a very different area than, say, the common law crimes. You can't get a permit to commit a robbery. You can get a permit to put, tainted water into a body of water. There's no limit on, the number of burglaries you can commit, that it's up to 10 is okay, after 11 it's not. There is a limit in the amount of waste you can put into different types of treatment plants. So what you have is an attempt to use the criminal law in a very rough manner, oftentimes in an area where it doesn't work well. And a lot of the laws in that regard don't use a mens rea concept of blameworthiness to make people into criminals. That's the sort of problem. Now, if you want to call that watering down the environmental laws, you can. If you want to say if it's making the laws correspond to the level of blameworthiness that is apparent in the conduct, then I don't think you would say it's watering down. You would say the people who know what they're doing is wrong should go to prison, and the people who don't shouldn't.
Those of you who took my criminal law class your first year, do you remember the Model Penal Code has a default rule of recklessness that if a statute doesn't specify what the required mental state is, the Model Penal Code says fill in the blank with recklessness. One of the pieces of this bill is essentially a default rule for federal crimes. If it's not specified, there's some minimal level of mens rea that's required for every offense. And the effect is being felt and opposed in the environmental area because that's one area where there are a lot of strict liability crimes today. And so it would be harder for the government to prove that a person knowingly violated the law or knowingly dumped more than the quantity of chemical into the body of water, whatever it is.
We have one more question.
Thanks for being here. I just have a question in terms of like what is being done, if anything, to address the issues of physical abuse and sexual abuse that's happening in our prison populations that more often than not has an effect on African American women.
I know the federal government passed a statute to try to require states both to report the number of assaults and to take steps to improve it. And the federal government has the authority to bring lawsuits against state prisons or local jails if one or the other is become a hellhole for the people who are there. How often they bring those suits, I don't know. There's a division at the Justice Department called the Civil Rights Division, and they have a subunit that deals with institutions, prisons, jails, mental institutions, and the like. They would be the ones that look into this. So from a federal level, I think the federal government has the authority to do it, but how many of these they're able to engage in, that I don't know. They've tried to deal with this. I don't think it's as big a problem in the federal system as it is in the state system, but I'm perhaps just biased towards the federal government against the states in that regard. I have to admit that. So I don't know.
Well, we want to thank you guys for coming out. We had a nice discussion. And on behalf of Federalist Society and the Black Law Students Association, thank you for being here and safe travels home. So,
thank you. My pleasure.